This fascinating case is one of my favourites. Hill was a staff member in a facility described back in the 1850s as a lunatic asylum. Hill was charged with the manslaughter of one of the inmates, Moses Barnes. A witness to the alleged homicide was a man named Richard Donnelly, also an inmate in the asylum. Donnelly almost certainly had schizophrenia, but that condition was unknown in the 1850s. He was regarded as being insane because he experienced delusions, believing that he was surrounded by spirits who communicated with him constantly. The interesting thing was that other than this specific delusion, he was perfectly competent. His memory was unimpaired, his ability to communicate was fine, and crucially, he seemed to understand the difference between thoughts of his own and thoughts communicated to him by the spirits surrounding him. Most importantly of all, he regarded himself as a devout Catholic, and in accordance with those teachings, he completely understood the nature of an oath to tell the truth. He said in evidence, "When I swear, I appeal to the Almighty. It is perjury, the breaking a lawful oath, or taking an unlawful one. He that does it will go to hell for all eternity." So, we have an eyewitness to an alleged offence, who's perfectly capable of relating what he saw, and who seems to completely understand the nature of his oath as a witness, but at the same time, who believes in delusions that he is surrounded by spirits who communicate to him. Should such a person be able to give evidence? The court said yes. Chief Justice Campbell said it is for the judge to say whether the insane person has the sense of religion in his mind and whether he understands the nature and sanction of an oath, and then the jury are to decide on the credibility and weight of his evidence. Justice Talford said it would be very disastrous if mere delusions were held to exclude a witness. Some of the greatest and wisest of mankind have had particular delusions. In Queensland, the rule set out in Hill's case now forms part of Section 9(b) of the Evidence Act 1977. If a person understands the duty to tell the truth and the nature of their oath, they are fit to give evidence, and then the jury must decide what weight to attach to that evidence.